All righty then. Thank you so much for showing up. We will start our presentation momentarily. Again, my name is Veronica Dangerfield. My comedy line is, I am Rodney's only Black child, full of jokes today. And we are going to be having a estate planning webinar 101. Today, we are so excited to be welcoming back a guest presenter. He's an attorney, John Fraker with Ann & Fraker LLP. He is a double major at UC Berkeley and obtains a bachelor's degree in both history and political science. He then went on to USC to obtain his Juris Doctorate. He finished his education at none other than the Golden Gate University School of Law and received his LLM in taxation law. Our guest presenter was admitted to practice in the state of California in 1999, and he co-founded A&R and Fraker in 2002. And he's also a licensed realtor with Keller and Williams. John presented to our Patelco partners in the past, and we are so pleased to welcome him back today to help us understand what we need to be thinking about when it comes to estate planning. John has generously volunteering his time today. He has many clients that are Patelco members, and should you ask to seek his services following the presentation today, he has a special offer to share. Patelco is not affiliated with A&R and Fraker or Keller Williams. All the information shared today is for educational and informational purposes only. So, all right, the next slide is that I'm from Patelco Credit Union, and we are here to make sure that you're living your best financial life. We want you to be able to manage effectively, to be resilient, to seize opportunity, and to rise up to your financial dream, whatever that is, as unique as a fingerprint on your finger. So when you take care of your family, take care of your assets, and you plan, you can seize the opportunities to make sure that you're taking care of your family adequately. So please, I am delighted to welcome John Fraker to Patelco. Come on in, John, it's your turn.
Thank you so much, Veronica, I appreciate it. All right, everyone, today's presentation, we're gonna be talking about estate planning for everyone. And I absolutely love the title of our seminar because estate planning is absolutely for everybody. It is not for Rockefellers only. It is not for Vanderbilts and the super rich. It is for absolutely everybody. And when I get to some of my presentation examples later on, we're going to find out that even estates that are comparatively modest here in the Bay Area and in Northern California, when they go through the ringer on some of these crises, it really impacts everybody. It's not just a matter of being for the rich and famous, it's for everybody. So let's jump right in. Veronica gave a little bit of my bio. I am native of here in the Bay Area, Northern California. So let's skip forward. I always start my presentation with a little bit of estate planning trivia. So the question I start out with is the one my clients ask me, when do I need an estate plan? And the answer is not until the day before you die. However, unless you have a crystal ball or magic 8-ball, you need to set your plan in place today because we really don't know when that's going to happen. And one of the things I love sharing with families in estate planning is the world is an uncertain place. Certainly, we've seen that in the last 2 years. And the way that we combat and deal with uncertainty in estate plans in our lives is by building in the maximum flexibility that's possible. So I always start off by talking about the high cost of procrastination. Obviously, that's something that factors in for families when thinking about estate planning and living trust. I don't really necessarily want to think about leaving this earth. I don't necessarily want to think about going to the hospital. So I'm going to start doing other stuff that I'd rather deal with and put this off. So roughly 70% of Americans die without a valid will or trust. And I always say that probably 100% of people intend to get to it. They mean to get around to it. It's something they knew in the back of their head, this is something I got to do. But something happens, life intervenes, they push the issues down the road, and life intervenes and you find yourself without an estate plan, and then it's too late. So what happens if I die with no estate plan? Okay, so in California, as in the rest of the nation, our probate process, probate is just Latin that means to prove the will. It means that they usher your will and your instructions to the court system. Intestacy is just a big stinking mess. I'm dealing with one right now, and I can't even describe to you how bad it is to go through the probate system with no instructions at all from the person who died. Who gets what? It's all going to be messed up from what the person who passed away last year, what they really wanted to have happen, and the people they really wanted to leave their estate to, almost certainly aren't going to be the people who wind up with the money from this estate. But unfortunately, they died before they were able to put something in place. Okay, so the number one thing that I communicate to my clients, that's a mistake that people make when thinking about their estate plan, is someone will come to my office and say, well, I don't really have an estate plan set up. Can you help me set one up? To which I respond, every single person in the state of California has an estate plan. You either have the estate plan that you yourself set up, your will, your trust, your documents that reflect what's important to you, your values, your wishes, what's important to your family, or you have the default. And that is the state of California's default estate plan for everybody. There's a big section of the probate code in California, as in most states, which is referred to as intestacy, the intestate code. And that, again, is the process where you have no will, you have no trust, you die, and your state goes through the court system flying blind with no instructions. So you're either going to have your own estate plan or you have the one California has created for you. So I can't stress this enough. You do not want the estate plan that California has created for you. It is bad news. And I put this together. This slide is a little bit tongue in cheek, but it says your will as drafted by the state of California. If you decide to go with the default estate plan that California has created, this is really what you're saying. Number one, I desire to pay the maximum amount of taxes possible. Item two, I believe in letting the state of California choose a guardian for my minor child or children. Number three, I feel the state of California or a judge would do a better job than I can in deciding who gets my stuff when I'm not here. And also, I prefer to let the state of California choose the executor of my estate. Obviously, these are silly. Nobody ever thinks this way. Nobody in my 20 years of doing this has come to office and said these things. But this is really what you have right now. You have if you have the California's default estate plan. So when you sit down with an attorney, what you're doing is getting away from California's will and creating one that reflects what's important to you. So let's talk a little bit about the disadvantages of probate. Number one, it's a very expensive process. It's very costly for your estate to go through a probate. Using round numbers, we estimate at a minimum, it's going to be about $23,000 to probate a $1 million estate right here in California. That includes real estate, that includes anything that needs to be probated. It's a very public process. Number three, I'm really going to harp on this throughout my presentation. How slow it is to go through the court system, especially now. It was slow before COVID. It was slow before the pandemic, but the court system here in the Bay Area has just completely come off the rails. I closed a probate later last week, and I had actually filed the paperwork to close it back in September of last year, 6 months. So I filed it, everything's done, every I's dotted, every T is crossed, hit submit, it's in the court's filing system, and they said, we'll see you to hear your case in 6 months. And that's just to close the probate. That's not the probate itself. That's sitting around waiting for the court to have time to hear your case. And while that's kind of an extreme example, the other courts in the Bay Area and elsewhere in Northern California aren't that far off from there. So when I say 9 to 18 months on average, you can really expect 1 to 2 years for your state to go through the probate system if you're in California, especially Northern California, the Bay Area, or if you're in a populous area in Southern California, Los Angeles County, Orange County, San Diego County. You're really going to go through a very slow process in any of the busy court systems here in California. They are all breaking at the seams. By contrast, having a living trust, you get to steer away from the court system. You get to have what we call trust administration. And trust administration is just the process when you have a living trust and your stuff is funded to the trust, how those items get to the next generation, to your intended beneficiaries. So the primary benefit is, number one, it's far cheaper to go through the trust administration process because you're staying out of the probate system. It's a private process. The only people who are going to see your trust are the people you have named in it, your heirs at law. They're going to see a copy of the trust, nobody else. It's not being filed with any court. It's a far faster process. You can get in and out in a straightforward estate administration process or trust administration process, somewhere 6 to 9 months on average, which is way faster. And that's because it's the process done between you, your attorney, in the privacy of your attorney's office. It's very efficient. You're not being hung up with a lot of the crazy just details that bog down probates in our court system. So let's talk now about the living trust. And in an estate plan, your revocable living trust here in California is the foundation of your estate plan. It is your bread and butter. It is the most important of all the documents that you have. It is your master set of instructions on what happens to your stuff if you're not here. It is also the place where you specify people who will be helping you if you're not able to do the job. If you're alive, you're in a coma, we have a lot of clients who come to us who are the trustees for their parents, and their parents have dementia, they have Alzheimer's, they're in a nursing home or memory care facility, and they say, well, my dad still owns a house, I gotta pay the mortgage, I gotta pay bills, how do I do that? Well, if you have a living trust, you have a set of instructions and authority for your family to help you out on that. So let's talk about some of the trust benefits. Because it is revocable during your lifetime while you're alive and in good health, you can make as many changes to your trust as you like. We strongly recommend not only having a trust, but updating it as your life changes. We've had people come to us with living trusts that were 10, 15, 20 years old and really didn't reflect the person's life at that moment. So we always want to make sure that not only that you set one up, but that you continue to examine it as you have major changes in your life. Number two, it provides for management of assets during incapacity. We talked a little bit about that. When you have elderly clients who are no longer able to handle their affairs, their trust and the supporting documents, that's what gives the authority to take care of your parents' stuff. So a living trust gives management of your assets during incapacity. You have some estate tax benefits. I'm going to kind of skim over that for this presentation. And it gives you, the person who is setting up your trust, complete control over distributions and also asset protection features. We're going to talk a lot about that because that's something that's super popular with our clients, is how do I make sure that the money I leave my kids winds up in their hands and not in the hands of other people. So this is true of all states. Until you are age 18, you're not legally allowed to inherit property free and clear. If something happens and you have no trust, a child's inheritance goes through the court system and gets managed via the court system. And then if you don't have a trust and you don't specify at what age they can inherit their property, the default for everybody is going to be age 18. And we always joke and say, you know, we like to think that it's a tough decision for an 18-year-old coming into a couple $100,000. Should I go pursue my degree? Should I continue suffering away in college? Or should I buy myself some luxury items, buy myself some friends and spend it all? We like to think it's a tough decision, but the science proves it is not a tough decision for the kids. Spending it quickly is exactly what happens. Every financial company, probably that you've ever heard of, that studies these things in depth, says that it's just proven numbers. A child who inherits property at 18, how long it takes them to burn through that money, usually by the time they're 21 to 22, they're flat broke again from their inheritance. They've spent it all. So a living trust gives you the benefit of protecting a child from their own poor decisions when they're younger, and later in life, you're protecting them from other people. A living trust gives you control over the distributions to your children. So we talked about that, what it looks like. You can distribute the property to them all at your death. You can also leave it in trust for them and distribute it to them in stages when they're older. And what that means is that they'll have income from the trust to pay for living expenses. They'll also be able to tap into all of the money that you're leaving them for anything healthcare related, anything education related. And that's broadly defined. It's not just university study, it's broad definition of education and training. Maintenance and support, these are legal terms that mean necessities of life. So what this means is that all the money you leave your kids, while it remains in trust, all of it is available for them for their needs. What it's not available for, therapeutic shopping sprees, buying some friends, basically luxuries, things that may not be the best use of the money you're leaving them. You can distribute the rest of the money to them when they're older in stages. Hopefully older and wiser go together, not always, but we'd like to think so. Distributing to them, say, for example, a third at 35 or 25, 30, and 35 when they're older. They have more responsibilities. Studies have shown that an 18-year-old may or may not have a lot of claims on their money. In other words, they receive an inheritance and they really have a wide open field for how they want to spend it. But by the time they're 30 and 35, they may be married, they may have a mortgage, they may have kids and a spouse and mouths to feed. So inheriting property free and clear when they're older, life has already made a claim on that money, and they're not really at luxury to just completely waste it. And that's some of the main benefits of a trust, is that you're able to leave money to your kids when it's of greater benefit for them and not encourage them to waste it when they're younger. The last section, we're going to talk about spendthrift provisions. This is asset protection. And what this means is that while the property remains in trust, it is immune from their creditors. And we're going to talk at great length about that in a couple more slides. So let's talk briefly. I'm going to give you a couple slides on funding. At the highest level, a living trust is, think of it as a container for your assets, okay? So you sit down with your attorney in their office, you go through the questionnaire back and forth, and you put together the best living trust you can possibly do. And then you leave your office of the attorney, sign the documents, notarize, your container is complete. It is not finished, your estate plan is not finished until you fund that living trust, until that container is now full of your stuff, right? So you put your assets into the container so that when you die, your children receive not an empty container, they receive the assets that are in the container. So one of the things that's extremely common over in my career is that somebody will come to me and they will say, oh, my mom's going into a nursing home. Can you help me understand my role as trustee? And they hand me a trust, and they may be 10 or 15 years old, and they will say, is this trust any good? And which my response is always the same. Whether or not the container is excellent, it's even more important to figure out how much of your container is full. Is it completely full? Is it empty? Is it half full and half empty? That's the stuff we need to get our arms around. So funding your living trust is just simply putting your stuff in a container, right? If you create the greatest container in the world and you leave it empty, you're going to give an empty container to your kids, and they're still going to wind up in the court system. That's extremely common. So the benefit, obviously, of a trust is that it's funneling the money to your intended beneficiaries, right? And not your unintended beneficiaries, your future ex-son-in-law and or creditors, predators, ambulance chasing attorneys, Uncle Sam, unnecessary taxes. You want to make sure that you're leaving money to the right people and not to the wrong people. Which brings us to what we hinted at earlier, Spendthrift Trust Provisions. And Spendthrift simply says, while your assets, your house, your finances, while they're in the living trust and they have not yet been fully, completely distributed to your kids, while they remain in trust, the inheritance is completely protected. And that means that creditors are not getting at your assets. Creditors cannot force distributions. If your trustee is managing it for the benefit of your kids and your child is going through a lawsuit or your child is going through divorce, really what the language of the trust requires is that the trustee kind of turns the spigot off of the money flow to the child, makes that money not available to them. And that way, if they get sued and they have a judgment against them or they go through a divorce, the money that you've left them is not available to be lost in a court battle, in a lawsuit, or in divorce. It remains within that fortress, within that protected wall for the benefit of your kids. And I really, really love emphasizing this because in the grand scheme of things, this is some of the most cost-effective asset protection that money can buy, just a simple living trust that you leave for your kids. It really provides great asset protection for your children. And they will have, again, as I mentioned before, they're going to have access to all the money for their necessities. They're still going to have food, clothing, shelter, tuition, rent, all that stuff, mortgages, everything paid by the trust. But it's not just they're spending money to lose in a divorce or lawsuit. And it does not mean that they are not able to access the money. We talk about the Rockefellers and the East Coast families that are on their fourth or fifth generation of hand-me-down wealth. Living trust, dynastic trust are the foundation of how they do that successfully. And those trusts really take the child's hands off the money. The trustee manages it for their benefit. There's really nothing that's in the child's name, and yet they still have access to all the family's wealth, right? They're still living in multi-million-dollar houses and compounds. They're still traveling the world in private jets and so forth. They're living the lifestyle of the rich and famous, but they don't necessarily own anything in their name. But the trust owns it, and that gives them complete asset protection for people who would try to separate them from their money. Accumulation provisions, we talked about that. That is where the trustee turns off the flow of money to your kids if they're being sued, and lets creditors and mostly their attorneys know that no money is going to be coming out to your child while this lawsuit is in place, and that promotes them to settle it instead of seeking the money that you're leaving your kids to fulfill their judgments. It really promotes settlement of legal claims. So spend-through provisions, I emphasize that a lot. That's some of the most popular stuff that clients talk to me about. If you have a child and they're going through a difficult marriage, and you're not sure, week to week, month to month, it's going to last. I kind of joke tongue in cheek, the most popular provision that clients would ask me for is actually not legal. And that is, I'm going to put a provision in my trust that this money only goes to my kid if they divorce their spouse. That's actually not legal. That violates public policy, and that's unenforceable. And so you can either tell your kid, hey, get a prenup. If it's too late for that, use Spendthrift Trust Provisions to make sure that the money you leave them is there for your child's benefit and not get blended in a messy divorce. So let's talk about the basic estate planning package. We've already gone through and emphasized the benefits of a living trust kind of as the foundation, but it is not your only document. You're also going to have a pour over will. If you have minor kids, any child under the age of 18, the will is where you list out who will raise them, your guardians for them. If something happens to you and your spouse, your will is where you list out who raises them. Your healthcare power of attorney and your financial power of attorney, those documents work side by side. And what that means, if you are alive, but you're incapacitated due to injury or illness, or in some cases, with elderly clients with dementia, memory loss, these are the documents that your kids need to take care of those situations for you. And then number 5, we're going to talk a little bit about grant deeds and why, especially in the Bay Area and in Northern California, with real estate prices where they're at, how a grant deed properly done can either save or cost you a lot of money. Let's talk about guardianship. If you have children who are under the age of 18, this is obviously the most difficult decision you're going to come up with in your estate plan. It is legally required if your kids are under 18 and something happens to their biological parents. It is a legal requirement that they have a guardian nominated for them and approved by the court system. It is legally required until they're age 18. What you want to do, how to choose the right person, you want to choose somebody obviously who's financially and emotionally stable, right? Somebody who's absolutely committed to the well-being and welfare of your kids. They don't necessarily need to be financial wizards. They don't need to be a JD, MBA, any of these advanced degrees or financial planners. They need to be good with your kids. You can always bring in other professionals to fill those other roles, financial wizards, tax person, attorney. Those people are easy to hire and bring in to round out their services that they're not good at. But it is impossible to hire a professional who's good with kids that's going to raise them. There's no such thing as professional guardians, right? So choose somebody who's good with your kids, who's going to do the closest amount or closest job of raising your kids the same way that you would. And I put this to the bottom in bright red because it's extremely important. Once you've chosen a guardian, please discuss that with them. You don't want to necessarily surprise somebody with the fact that they've been nominated as a guardian and they find out after you've died. I've actually been involved in probate cases where the first time somebody learned that they were the guardian for their siblings' children, their nieces and nephews, was when after they found out their sibling had died. That's not the time to do that. You want to talk with them about it early and often, communicate, let them have feedback, figure out how that's going to be worked out. Obviously, it's an extremely important role in your estate plan if your kids are under 18. So you don't want to leave that to chance. You don't want to surprise anybody. You want to have that conversation, even if it's difficult to have, you want to have that conversation early and you want to have it often and let them have some feedback on it. So your advanced healthcare directive is another document that's critically important. Obviously in the last 2 years with COVID, with a healthcare emergency that the whole state and nation is facing, you want to make sure that these documents are lined up. And you also want to make sure that you have ready and easy access to these documents in an emergency. And so we had one of our clients, actually a client of my business partner, Leon Ainer, husband and wife contracted COVID. This is March of 2020. And they were some of the earliest people. One of them was actually one of the first people in the Bay Area to die from COVID early on in March of 2020. And what had happened is that both the parents get transported in ambulance to the hospital. They're in the intensive care unit. The kids called us up, said, "Hey, can you send us a copy of the trust?" And we said, "No problem. But also, did you know your parents' binder is in their house?" And the kids said to us, "Oh, we're not allowed to go inside the house. The health department has put a tag in front of the house. We're not even allowed to walk inside the door of our parents' house." And that simply illustrates that having your documents readily available in an emergency is every bit as important as having them lined up, buttoned up, and make sure everything is done from the legal perspective. You want it, you want nothing left to chance. And that's because we always emphasize to some extreme, to some extent, the living trust is this way, but it's certainly true of these documents. You sit down in your attorney's office, you draft them while you're in good health, you're in sound mind, you're having more or less a peaceful conversation with your attorney generally, and then they're executed when stuff is kind of hitting the fan. When there's an emergency, somebody's being transported in an ambulance to the hospital, that's not the time you want to be stumbling around, your kids stumbling around looking for your documents. You want to have all that stuff on autopilot. And we show our clients how to do that. The advanced healthcare directive is where you state your wishes on life-sustaining treatment. Your agent is carrying out your wishes. They are not carrying out their wishes. And I emphasize that time and time again. This is nobody's decision but your own, but you want to make sure that your stuff is in legal effect, because without it, the state of California, like every other part of your estate plan, the state of California is going to do something that's right for them that's probably wrong for your family. So that's why it's critically important to have a healthcare directive signed and executed, ready to go. Another document, we call this one your durable power of attorney. This is legal signing authority for your name. If you are live but you're incapacitated, somebody else needs legal signing authority for your name. That covers all aspects of your finances, whether or not it's in the trust. So when you're talking about life insurance, you're talking about annuities, you're talking about 401ks or IRAs, those are never going to be owned directly by the trust while you're alive. So the power of attorney is necessary to update your beneficiary designation forms if you're not able to do that. Social Security is a big one. One of the number one things we see is that somebody will have, parents will be on Social Security. They'll be set up on auto deposit and just have this, automatic drip of money from Uncle Sam. And then they forget about it. They don't put that bank account in trust, and it grows over time. And they've been living off other money. And suddenly this account is outside the trust and it has more than $100,000 in it. And it may be headed to probate. And then the parents are now incapacitated. Without the power of attorney, your kids are going to find it really difficult to get that account into your trust. And again, you want to make sure that you don't have any assets going to probate. Even if your trust is mostly funded, you want it fully funded. So let's now talk about grant deeds. This is something I run into and have run into now 9 out of 10 times in dealing with husband and wife in how their deeds are titled and why it's a big deal, especially in California. So if you own real estate in the Bay Area or Northern California, basically anywhere in California now, and you bought it in the 1960s or the 70s, or even the 80s or 90s, you're sitting on a lot of money in built-in capital gain, right? Especially in the Bay Area. I have lots of clients that I've dealt with who have more than $1 million in capital gains, some over 2 million in Saratoga, in Los Gatos, and Palo Alto. Had pay a couple $100,000 for property in Palo Alto or Menlo Park in the 70s, and now it's worth 50 times that. So let's talk a little bit. I'm not going to go too far into details on capital gains, but at the highest level, what you buy something for and what you sell it for, the difference in between is generally considered capital gains. On your primary residence, if you meet the government's criteria, you can exempt the first $500,000 of gain. If you're above that, you may be subject to capital gains taxes on the difference. So why that is important and what does your grant deed on your house have to do with that? Very, very important issue. And again, I see this done wrong 9 out of 10 times. If you pull up the grant deed on your house and it says husband and wife joint tenancy, right of survivorship, anything other than community property, you're definitely going to want to meet with an attorney and get that looked at and see if that's something that needs to be changed. And here's why. If you die owning real estate as community property, if either one of you dies, the IRS and the franchise tax board, they give you a full stepped up basis. All that means is that if you own property as community property and one spouse dies, it eliminates all of your capital gains. And that in many cases can be 6, in some cases 7-figure tax bill. If you, on the other hand, if you own the property as joint tenants, it only eliminates half of your capital gains. So the difference between community property and joint tenancy is whether or not you eliminate all of your taxable gain or whether you eliminate only half of it. And what that can mean for families is a lot of money. I'm going to give you one example, which is, it's a little bit of an outlier, but it's honestly not all that uncommon. So I have a client, I did their trust for them. They were from Sunnyvale. They bought their house in Sunnyvale, in one of the more affluent zip codes of Sunnyvale, in I believe it was 1958 or 59, for $25,000 when Dwight Eisenhower was president. And in 2007, they had set up their trust. They put it into community property to eliminate their capital gains. After they left my office, they went out, they refinanced their house. The title company took it out of the trust, which I created for them, put it into joint tenancy, put it back into the trust. So when the first spouse died in 2016, the fair market value is about $2 million. And because they owned it in joint tenancy, they did not get the full step up in basis. So the kids came to me and said, Dad has died. Mom's in a nursing home. This is a very middle-class family. These are not tech titans. These are not billionaires by any stretch of the imagination. And we're burning through about $10,000 a month on mom's healthcare. And so what are we going to do on that? Can we sell the house? If we can, how much potentially would we pay in capital gains? We ran the numbers for them. If the IRS said that they did not get the full stepped up basis, that was actually a tax for them that would be over 6 figures. And so they looked at that. They said, that's just too much money to give in taxes. We're going to find some other solutions. And had they simply owned it as community property, they could have sold it all at the same time and paid no tax. So how the deed is written and how it is titled is a big, big, big deal if you own real estate in the Bay Area, especially if you've owned it in the 60s, 70s, 80s, or 90s. So we're going to segue a little bit to the last part of our presentation, and we talk about, this is the section that I call, how much is all this going to cost, right? People say, hey, this sounds great. I'm interested in getting a estate plan, living trust. How much is it going to cost? What does it look like? Okay. So let's talk a little bit about estate planning finance and how that works. You do have choices. You do have options. You don't, obviously, not everybody in the world has to work with our law firm. You do have options. So option one, you have the no planners, the folks who do it themselves, or they mean to get around to it and they just don't. We talked about that before. Life intervenes. They always meant to have a living trust done. They put it off and then they die, right? So the no planners, the upfront cost, hey, it's free. It doesn't cost anything to have no plan, right? On the back end, probate fees can be anywhere 3 to 5% of the value of your estate and a crazy amount of liability for your family. You have what we call, referred to in the industry as trust mills. Those are the volume shops that crank out hundreds, if not thousands of trusts per year. And they really are emphasizing the documents, not your family. Obviously, the most famous one is LegalZoom. They are a document preparation service. They're not a law firm. If you ever have interacted with LegalZoom and you've gotten stuff from them, you purchased it, you've always seen size 4 font at the bottom says, we are not attorneys. If you blow this up, your estate blows up in court, we're not responsible. You can't sue us. Take it to a real lawyer and have them evaluate the stuff that we've done for you, right? That's their whole pitch. That's how they limit their liability. By definition, the document prep companies, the trust mills, not being attorneys, can't stand behind their work. If something blows up, you can't sue them. They have no malpractice. There's nothing you can do about it. You can't get them to fix it because they say we're not responsible. You also have some trust mills that are run by attorneys, unfortunately, where they do high volume and they really spend almost no time with their clients. And we talk about this a lot. I'm going to emphasize this a bunch. The living trust, the documents are not the most important part of your estate plan. The most important part of your estate plan is your family, the people involved. The point of the documents is to make it reflect what's important to you and what's important to your family and make it fit your family situation, right? So I've seen some documents that were done by cheapies, you know, the $5 trust stuff ripped out of a book, and that's a train wreck. I've also seen some estate plans that were done by very prestigious law firms that didn't even bother to get to know the family. And it would have been the perfect plan for 99 out of 100 clients. And it would have been a train wreck for that family because it didn't take into account the people involved. So on the far right, you have estate and tax law firms, such as John Erik Fraker, our firm, and people who do this for a living. That's their primary, how they feed their families, is doing estate planning. We don't dabble in this. We've been doing exclusively estate planning and the surrounding practice areas for more than 20 years. Even before we started our law firm way back in 2002, both myself and my business partner were trust officers at banks. So we've been in this industry since the 90s, and we've administered thousands of trusts. And so when we're drafting documents, we keep in mind, these are human beings involved, your family, your loved ones. It's not just the documents, it's making the documents work for your family. So I'm going to give you a couple of examples, and I want to make sure that we leave plenty of time for Q&A. So I'm going to skim some of the examples. If anybody wants to go over the slides later, I'm happy to send you a copy of it. Not a problem. So if you're in the no plan, you die without an estate plan. We talked about this before. The statutory fee for probate is set by the legislature. It's not subject to haggling or bargaining. It's set by the legislature. And that's the probate fee that's set for a 1 million estate. The attorney's fee is $23,000. If you don't have a will or you don't force your executor to work for free, they're entitled to the same fee. So that's another 23 grand. You throw in the appraisal cost, the other filing fees, suddenly you're looking at anywhere 4 to 5% of the value of your estate in the probate system goes to fees and costs. The families who say, how hard can it be to do it yourself? And again, this, especially in the Bay Area, this covers all families have in many situations. It's not necessarily the super rich or the super not rich that fall in this category. A lot of people, very smart, very intelligent, very wealthy, highly educated, who say, it isn't that difficult, I can do this myself. And the answer is maybe, but a lot of people have gotten themselves a lot of grief with that exact attitude. I've seen small estates do it. I've seen 10 million estates do it. It's just, it really isn't worth it. We had one family, this gentleman had about a $500,000 estate, one house, had a bar, cash business, taxes were in shambles, personal property designation made no sense. He had his buddy, his drinking buddy, who also kind of did his taxes, tear something out of a book, put his name on it, called that his trust, right? So up front, didn't cost him anything. In the back end, he wound up spending, $55,000 in a year and a half to get his estate administered. So when you really figure out how much this costs, it's not simply a matter of how much do I spend up front, it's how much my family pays to get the property out of my estate and into the beneficiary's hands. The people who meant to get around to it, we had an intestate case that was $6 million estate, 3 very affluent properties that wound up in about 3 years of litigation, split 24 ways. Most of the people who inherited were strangers to the guy who died. Let's talk about this one, should probably be taught in law school, case books. This gentleman owned 28 properties in the Bay Area, very affluent estate. The person did his taxes, said, hey, don't spend a lot of money on an attorney. Just go over to a trust mill, crank out the docs, say what you want, great. In our industry, for people who have been practicing in this area more than a year, there are certain red flags. Blended families are the reddest of flags. And that means in this situation, second marriage, kids, the first marriage. That is almost always a situation that if it's not done with the utmost delicacy, will blow up in your face. And that's exactly what happens. So this gentleman went to a trust mill, and to the trust mill's credit, it said in his document what he wanted to have happen. I leave 4 properties to my wife, including our residence. I leave the other 24 properties to my children and to my sister. He died thinking that's what's going to happen. It did not. When he died, his wife took the documents and the deeds to a big law firm, and they pulled up all 28 deeds, and they all said the same thing. Husband and wife, joint tenancy, right of survivorship. What that means in legal terms is that at the moment he died, all of that real estate belonged to the wife, and the children were legally disinherited at the moment he died. So he died thinking that his trust said something, which it did, but it had no legal effect. Remember what we talked about before, the container and putting your stuff in the container? He had a container, it wasn't very good, but the real problem, the nightmare for his family, is that the container was empty when he died. And so that sucker went on for more than 7 years of litigation, attorney's fees well north of 100 grand. And in my opinion, the real tragedy for that specific family is that before he died and people started suing each other, they actually got along fairly well. For a blended family, they did about as well as anybody could. They vacationed together. The kids referred to her as mom. even though it was not their biological mother. They really got along well, and everybody's on the same page. He died, and unfortunately, the wife decided, I'll give them something later, but I'll take my time in doing that. And really, this is all mine anyway. And if I feel like giving them something, I will. And the kids, obviously disagreed. And so they filed litigation, and that went on for years and years and years. And so not only did it cost them hundreds of thousands of dollars in legal fees for nearly a decade of lawsuits, it also resulted in their family being absolutely destroyed, people wanting each other dead, where they had previously got on famously. So when you look at a tragic situation, this is front and foremost, in my opinion, is not just that there's a financial loss. This is a very wealthy family. And if they lost $1 million, they're still going to be fine financially, but their family is destroyed. So when you ask how much an estate plan costs, it isn't the upfront piece that you need to worry about. The real cost of this family is hundreds of thousands of dollars, a decade of litigation, and a family torn apart. That's the real tragedy for them. I'm going to kind of skim this one because I see we're getting towards the time we need to start doing some Q&A. This is an estate that was done by an attorney who really did the volume, kind of the trust mill process. This lady passed away, had no kids, left $2 million to her niece. Unfortunately, she amended her trust basically 5 times the last 8 years of her life, meaning about every year and a half. She was updating her documents and taking money away from people and adding it to other people, which is a mess. When she died, they found out that the house was going to her caregiver, which is a violation of California law. You cannot in your state have your house go to your caregiver for obvious reasons without a whole host of safeguards, including certificate of independent review and a bunch of other stuff that was missing. That wound up in about 1.5 years of litigation just to get that house back from the caregiver. Still had to give her some money to settle the claims, still had to pay lawyers. It was a big mess just to get out of that. And the second that case ended, there was another lawsuit filed against this trust. Someone who thought, hey, I was a beneficiary under the 3rd version of the trust, and then you took me off. Well, I think I can shake some money out of it and file a lawsuit. So the net result for this family was about 3 years of litigation, 2 separate cases, more than $100,000 in legal fees, a couple $100,000 in legal settlements to get out. So again, what's the cost of this estate plan and this disaster? Not the upfront cost, it's the back end. She had a cheap estate plan, but it wound up costing her family almost everything on the back end. Obviously, we recommend getting it done right the first time. Spend the money that's necessary to get your estate plan done properly by a law firm who knows what they're doing and stands behind their work. I can't stress that enough. You have to work with attorneys who will stand behind their product. If something goes wrong, they're going to step up and make it right for your family. I've seen that happen multiple times with other law firms, and we've had to do it every now and then ourselves. So you really want people who will stand behind their work and make it right if something goes wrong. LegalZoom will not do that. They say that in their documents. Trust mills, non-lawyers, financial planners. We had a 10 million estate where they used a financial planner, and that was just a giant train wreck. I mean, it literally hit every problem that you could possibly hit. And what are you going to do? The guy's a financial planner. He's not even licensed in California as a planner. Who did your documents? $10 million estate. You save some money, and you wound up with an absolute train wreck with hundreds of thousands of dollars of liability. Who are you going to talk to about that? It's a financial planner. It's not an attorney. You save some money, and you wound up costing your family a train wreck on the end. And then lastly, as I've emphasized throughout, really understand estate planning is a relationship-driven industry. It's not document-driven. There are financial companies like we talked about, LegalZoom and other companies who do Super Bowl ads. They spend billions of dollars every year to emphasize this is about documents because that's their industry. They are document providers. It is not about the documents. It is about your family and make sure the documents fit your family. I've seen so many plans where the documents were average, but they were just a train wreck for that family because they had no consultation with a lawyer. They weren't able to run various ideas back and forth between their attorney. And it wound up being a train wreck for that family. This is a slide. This talks about some of the other resources that are available to you guys via Patelco. Go ahead.
I can just jump in here.
Yeah.
I just want everybody to know that Patelco has my financial journey. If you have challenges with your budgeting or you have questions about your credit, we have free certified financial coaches that can support you. We also have additional information at Patelco at Balance Pro. And of course, if you go to our website, you can find a lot of amazing information to support you in your financial life. And but we do have some questions here. If you can hop back on and we can,
Yeah.
you know, there was a lot of questions regarding who needs a trust. Do you need a trust when you're single? Do you need a trust when you don't have any children? Is it determined by how many assets you have? How do you answer that?
Excellent question. So what I recommend for families, there's a financial aspect of it and there's a family aspect, right? So if your estate is under 150, 160,000, you might be able to get away with what we call the small estate procedure. We use those documents all the time to administer tiny estates where, you know, one bank account, or maybe an estate where there's a living trust that covers most of it, and then one or two accounts get left out. Small estate affidavit process, where there's a very small estate, again, under 160,000, they're not going to probate. So from the financial aspect, if you're above 160,000, that's one time you want to look at having a trust. The other, which is equally important, is the family aspect. If you have minor children, any size estate, you got to have a living trust. Even if all you have for your kids is life insurance, it has to go into a trust, because if you have life insurance for a minor, we had this happen to a family of ours. One of our clients, husband and wife, came to us about 4 days before the husband passed away. He had pancreatic cancer. He was in his early 40s. He had a wife, a 2-year-old and a 4-year-old. And we put together a trust on the spot, put his house into it, did everything properly. And then after he died, they found out he had a life insurance policy at his company. And it said half the death benefit to my wife and half to my 4-year-old daughter. And unfortunately, because she's a minor, the insurance company held back her 50% until the mom had to go to court and open an account, especially a special guardian account for her daughter, and basically not touch that money until she's 18. So that's an example of, even though the estate was not enormous, the fact that there's minor kids, you got to have a trust. Even if you don't have a single dime to your name, but you have minor kids and you have life insurance that's going to them when you die, a living trust is absolutely indispensable.
There's a lot of questions about having a will and having a trust.
Yes.
And you know, what goes in the trust, what goes out of the trust, and who determines who goes into the trust? Because I have a question where a mortgage banker did not want to put the house in the trust. Can you speak to that?
Absolutely. So a will and a trust, when you have a living trust-based estate plan, they are complementary documents that work side by side with each other. Your living trust, if you have a living trust, that's where the who gets what stuff goes. Okay. Your master set of instructions on who gets my stuff when I'm not here, all that is part of the trust. And so that's not the point of a will when you have a living trust process or estate plan. The will is where you do two things. One, we call it a pour over will. Number one, if you have minor kids, that's where you list guardianship. And item two, if you have any asset that did not get put into your container while you're alive, the pour over language of the will says, I'm opening a probate, I'm taking that asset and I'm pouring it over to the trust, funding it after the person dies. Because if somebody has died and their container is empty or only partially full, the pour over will is how you get that asset into the trust after somebody's died. So we strongly emphasize the benefits of funding your trust while you're alive to get away from that. It doesn't happen all that often, but as a cleanup document, the pour over will is also part of your estate. So in a living trust-based estate plan, you do need both documents, a will and a trust, but the trust is what does the heavy lifting of your estate. It's the who gets what.
Perfect. We have a lot of questions about if you have a trust and mom and dad has a trust, but you talked a little bit about this earlier. What should parents, responsible people do in informing their children where their trust and important papers are? Should you mail it to them? Can they go to their attorney and find the trust there?
Yeah, excellent question. That's something we talk about with all of our clients. So under California law, the Business and Professions Code for the attorneys, we don't keep originals for our clients. So when we're
Mm,
done, trust, container, done, funded, the binder goes to the client. We also give for ourselves, this isn't every law firm, we give every single one of our clients their documents scanned to PDF format so they can have the hard copy and then keep that in a safe deposit box at the bank.
mm.
They can keep it in a fireproof safe at their house. And then they also have a digital copy, a PDF copy, which is a scanned copy of the entire binder. The reason we do that is that's the easiest way to get those documents to your kids, to share it with them, to share it with your, if you have a professional trustee that you're working with, you give it to them. CPA needs it, anybody needs it. A digital copy can go to those people. So that's usually how we recommend. That's how most people do it. The original stay with the client, and then they send digital copies to the people who are named in it if they want to reveal that to their kids.
Can you go to the next slide, because there's a lot of people asking for your
Drum roll.
information, and and I want you guys to know there's hundreds of questions, and unfortunately we're not going to be able to answer all of them, but he has some really great information where you can actually get your questions answered.
Yep. So I want to emphasize this one slide because this is extremely important if you are a Patelco credit union member. Our basic estate planning package, right? We talked about how much this costs. Our normal price, if you came to my law firm, not from Patelco, you called me out of the Yellow Pages or wherever, you found us on the internet, our standard estate planning package for a living trust-based plan is $2,500, right? That includes the trust, the wills, all the powers of attorney, and the grant deed. That also includes phone calls, emails, everything necessary to get your estate plan in order and your documents off the ground, ready to go. The only thing it does not include funding, and it does not, because I'm not the one who's actually able to do that, and it does not include the notary stuff. So the exclusive offer that we have for Patelco members, instead of $2,500, you have the opportunity of only having to pay $1,500. So it's $1,000 savings if you are a Patelco member. If you're not a Patelco member, that's an outstanding reason to become one. Is because you're going to save $1,000 right off the top of your estate plan.
So
sorry to interrupt. I put my cell phone there. If anyone wants to talk to me about their stuff, all my contact information is on these slides.
Yeah, everybody, we will be sending you a copy of the presentation and momentarily. Once it gets finished recording, I will send it to everyone who attended and also people who did not attend. But John, another question is, when I have a trust and it's made in California, does it travel throughout the United States with me? Is it valid in other states or
Absolutely.
either other countries?
So 2 questions. In the United States, absolutely. A California trust is valid in all 50 states. And one of the benefits, to be honest with you, if you happen to own property in more than one state, you own a house in another state, you absolutely have to have a trust, because otherwise you get the joy of probate in every single state where you own real estate at a minimum. So if you own a house in California and a vacation home in Florida, you're going to have a probate here and you're going to have one in Florida for that asset. The trust gets you away from that. So that's one of the critical elements and one of the main benefits of it. But to answer your question, yes, it works in all 50 states. If you move from California and you go to another state, we always recommend that you consult with an attorney in that state about how our documents or your estate plan may need to be modified. The primary difference that you're going to experience in another state has to do with what we talked about with community property. California is one of only a handful of states that are pure community property states. Especially if you move from California, you go east of Mississippi, you're not going to be moving to a community property state. And that has financial and tax ramifications for your plan. So we just advise people, it doesn't mean that our documents stop working. It means that you need to consult with a legal expert. We only practice law in California. I only give advice in California. So we do recommend, if you do move to another state, that your documents are reviewed by an attorney, by counsel there. And you may need to change some stuff. You may need to change nothing.
John, my trust is 10 years old. So is there anything that I should do? I mean, how do I evaluate whether it is still valid for my circumstances today?
Yep. So the best way to do that, honestly, is just to talk with an attorney. we always emphasize there's a couple of different points in which you want to update and freshen up your living trust, your estate plan. As you talked about, the older it is, the more likely it is to be wrong. The best way you can really think of an estate plan or a living trust is it's kind of like a snapshot of your life, your financial and family life today when you execute it, right?
Right.
If nothing in your life changes, I've had clients where literally nothing in their life changed for 20 years. You know, retired gentleman came to me, one house, one IRA, 2 kids. 20 years went by in his life. He died, one house, one IRA, 2 kids. Like nothing changed. Didn't need to update his plan at all. His family had not, you know, everything was set in stone and did not change. But if your life does have changes, you add or remove beneficiaries, you come into a bunch of money, you inherit money from a parent, and you want to include that in your estate plan, you want to update your documents to reflect changes in your financial life, changes in the people. 10 years is almost always a good time to at least sit down with an attorney and talk about redoing it. One of the things that we're seeing more and more of, it wasn't this common early in my career, it's very common now, powers of attorney not being honored by financial companies that are older than 5 years. And it's not because they stop working. It's not because they're invalid after 5 years. It's not anything with the law, but financial companies are afraid if I honor a power of attorney and it's 10 years old or 15 years old, and I put the accounts in this kid's name, how do I know I'm not going to get a lawsuit suing us because somebody else pops up with a newer power of attorney, right? And so we're seeing that become extremely common with powers of attorney that are 5 to 7 years old and older. The gentleman that I gave you that example, where nothing in his life changed for 20 years, his power of attorney, the IRA company didn't really want to honor it when the daughter took over. And it was nothing wrong with it. It is 10 years old. I'm like, didn't need to update it. The man has not changed anything in his life in more than a decade. But they were just concerned. They're like, how do we know someone's not going to pop up with a newer power of attorney? So we had to fill out a bunch of other work, paperwork, and attest that no other powers of attorney are floating around out there. So that's kind of the best way to think about updating it. If your family changes or your finances change, you want to meet with an attorney and update your plan.
So you said family changes. If I did a trust when I was in a domestic partnership, and then I got married, or I had children, is that a great time?
Those are outstanding. Those are outstanding reasons to update your plan. But even if you don't add or remove family members, as the saying goes, as kids get older, that's an excellent way. I'll give you an example. We talked about guardianship, right? Who's going to raise my kids if I'm not here? If your kids are young, 2, 4, 5, 6, 7, young kids, you may choose people out of state who are your family. When your kids get older, say they're in high school, they still need a guardian until they're 18. But let's say now your kids are 16, 17. They have their established relationships. They're on sports programs. They're wedded to their community. You might make a different decision for a 15-year-old or a 17-year-old than you would for a 4-year-old. Those are totally different universes. And so even though the same number of kids, the fact that they're older and they have a more established life, you might make a different decision as they get older. So those are some reasons you want to update your plan, or at least think about it and talk it out with your attorney.
John, we were delighted to have you here. You were so informative and entertaining. Thank you so very much for coming. We will be sending out a copy of this to all of you. So don't you worry. And we will continue giving you the best webinars with relevant information to increase your financial capacity always. We love you. We thank you. And we will be seeing you on the rebound. Thank you for coming, and good night. Good night, everybody. Thank you.